I've had the thumbs up, so we can start. Well, first of all, I should just come clean and reveal that I am not, in fact, the person who's supposed to be chairing this session, who is going to be my colleague, Joanna Lewis. She's not very well. I'm Tim Allen. I'm the director of the Firoz Lalji Institute for Africa, which also incorporates the Centre for Women's Peace and Security. And we've been working on issues that we're going to be discussing today for a long time. Much of my own research has been on war-affected areas and how they affect women. And I was actually a witness at the International Criminal Court when our first speaker was the prosecutor. So we've got a really interesting panel. We're very pleased to have Her Excellency Fatou Bensouda, who years ago worked at the Rwanda Tribunal, and then in 2004 moved to the International Criminal Court, and she became the chief prosecutor at the International Criminal Court, where she came under a lot of pressure over the International Criminal Court just prosecuting Africans, and was rather fierce in responding to those. Nobody's saying that anymore, I notice. So things have moved on. So it'd be really interesting to hear from her. Then we've got Rita Kahsay, who runs an NGO and be working mainly on Tigray, the terrible things that have been happening in Tigray recently, and is going to be talking a bit about that. She also has a book. Do you have copies of your book? Hold it up. Don't be shy. She has a book, yeah, about the experiences in Tigray. And then we've got Claire Wilmot, who is also a new entry into the panel due to sickness. And she also works on, you work on Tigray too, I think, to some degree. Yeah. Yes. But then you're looking more at kind of how legal processes are actually applied in practice by officials who are meant to be implementing them. And Claire is a journalist, and she has a PhD from here at the LSE and is linked to the Centre for Women's Peace and Security. So we've only got an hour, so I think we should go straight in. Can I ask you to, well, you've got something to say, so maybe yes. I won't ask you a question. But I'm just, I'd be really interested to know what you think about, the...
Because I understand that you're supposed to say something for 8 minutes.
Yeah, for about 8 minutes. Yeah. Perfect.
That's why.
Yeah, that'll be fine.
All right, sure. Well, thank you very much, and I thank the LSE Festival for inviting me. It's really a topic that is very much, very close to my heart, and something that I feel I'm very much invested in. So, panelists, my regards to all of you, and it's really a privilege to join this esteemed panel and to discuss one of the most critical issues of our time. And this is the protection of women in conflict through the power of the law. And as someone who has dedicated my career to the pursuit of international justice, I am deeply moved by LSE's commitment to shedding light on this often overlooked but profoundly consequential topic. Throughout my journey, from the courtrooms of the Gambia to the hallways of the International Criminal Court, I have witnessed firsthand the disproportionate and devastating impact of armed conflict on women and girls. And I have seen the transformative potential of the law to provide a measure of justice, of healing, and of hope. And as the immediate past chief prosecutor of the International Criminal Court, I see this as an opportunity to be able to review and to take stock of our achievements, but also of our challenges. And in this sense, I believe the way that international criminal justice has evolved, especially in the recent decades, regarding the way it addresses sexual and gender-based violence, is very reflective of how far we have actually gone. Remember that Robert Jackson, the chief prosecutor of the Nuremberg Tribunal, decided not to present sexual crimes in the cases against the Nazi leaders, even though we knew that it happened and it took place, but he did not charge them. And indeed, the efforts that have been made since the mid-90s to obtain accountability for atrocities committed against women during the conflict in the former Yugoslavia helped establish how rape and other sexual violence could be instrumentalized in a campaign of genocide. And this equally contributed to the expanded understanding of sexual or gender violence as war crimes and crimes against humanity. But perhaps the most groundbreaking decision advancing gender jurisprudence worldwide is the Akayesu judgment, which was delivered by the trial chamber of the International Criminal Tribunal for Rwanda on the 2nd September of 1998. And for the first time in history, rape was explicitly recognized as an instrument of genocide. And as described by the ICTR then, in that case, the Akayesu case, rape, they said, is used to kill the will, the spirit, and life itself. That decision, the ICTR decision, the chamber provided a definition of rape within the context of conflict. And it says that it is a physical invasion of a sexual nature under circumstances which are coercive. This is what the chamber said. And by doing so, they actually placed gender crimes in a larger context. Moreover, also the Special Court for Sierra Leone, we saw, has addressed the issue of forced marriage as a crime against humanity. The Rome Statute of the International Criminal Court is thus the result of a recent evolution in international law, recognizing gender violence and gender crimes. However, it is only in the statute that a basis in gender first became an element of crime in positive law, specifically persecution as a crime against humanity. And various provisions of the statute also prescribe what can be characterized as gender crimes, such as rape, sexual slavery, enforced prostitution, forced pregnancy as a war crime, and or as crime against humanity. If you look at Article 54 of the Rome Statute of the ICC, specifically, it provides that the prosecutor shall take into account the nature of the crime, in particular, where it involves sexual violence, gender violence, or violence against children. It's very, very specific. And then Article 49, also 42.9 of the statute requires the prosecutor to appoint advisors with legal expertise on specific sexual and gender-based violence. So, and let me just stress here that this is not only a statutory obligation, but it's also a requirement for effective investigations and prosecutions of the crime. During my tenure, I did establish what was known as the Gender and Children's Unit. Actually, it was first established by my own predecessor, Luis Moreno Ocampo, and I developed it further when I came. Perhaps I will pass on the floor, but I just wanted to emphasize that these are crimes that really were not fully addressed or comprehensively addressed before. It was really minimized, it was trivialized, and we know that in conflicts it happens. It takes place all the time. But we saw that in the past, it was not boldly charged, if I may put it that way. It was not boldly brought into the investigations and investigated. But as we go on and discuss with the panel, I hope we will show how it has evolved, how now, I mean, if you look at some of the sections of the ICC statute, which I believe that is really a very advanced and comprehensive one on sexual and gender-based crimes. I think that we'll be able to show that advancement has been made, but there's still a lot to be done.
Thank you. That was really interesting. I just want to ask you just a couple of things, just to sort of clarify a few points, because I think they're really important. That while you were prosecutor, a new initiative was introduced whereby very vulnerable, sexually abused women were able to testify before the trial started. I'm thinking here about the trial of Ong Wen. And that was a really kind of pioneering development that hadn't occurred before, and allowed those women who wouldn't have testified otherwise to speak about what had happened to them. Could you just say a little bit about that?
Yes, sure. As I said, there is a provision that the prosecutor has to take special measures to ensure that these crimes are very well investigated and prosecuted. So for me, it was really very, very important from the beginning, and I saw the statute as an opportunity, really, to be able to do much on how to investigate and prosecute. First and foremost, what I did was to introduce the policy. It's the sexual and gender-based crimes policy, which was one of the first, well, in fact, it was the first. I'm not beating my chest, but it was the first that an international court or tribunal was able to publish. And I launched it just 2 years after I took office as chief prosecutor. And there, we came out with the policy after a lot of consultations with everyone, with academia, with states parties, with NGOs, with everybody who was a stakeholder. We consulted with and took ideas from everywhere. So one of the things that we really did was how to ensure that the victims can feel comfortable to give their evidence. This was important because if you go ahead without having the evidence to be able to charge for these crimes, you will not be able to charge them properly. And victims, because once they're victimized in these kinds of crimes, there is a stigma on them. In fact, they become doubly victimized, if I may put it that way, and they are traumatized. So they hardly will tell you what happened to them. Sometimes when you're investigating, they will tell you that this happened to a friend of mine, but they don't want to assume it. So what we had to do was ensure that we give them enough protection and enough discretion to be able to take their evidence in various ways without exposing them, re-exposing them, and especially without traumatizing them, re-traumatizing them actually. And you found, for example, in the Bemba case, you found that in the end, witnesses or victims actually were volunteering to come forward to be able to give their evidence and for us to form the case. So this is one of the ways in which we tried to get the evidence from.
But I suppose a key point to make is that they gave their testimony before the trial started, so
Absolutely.
they gave it in, to some degree, in confidence.
Yes, yes. The confidentiality is critical. It's really very, very important. As long as they felt secure that they do not have to come before a sitting, a public sitting, even one done in camera, but to know that they're able to give their statements and talk to the experts from the office, the investigators, and the psychosocial experts, and all that. So this really helped for us to be able to bring that evidence forward. But
it is very difficult to do that in an African war zone, and we're going to come to this in a moment, isn't it? I mean, how do you protect those people? Because those witnesses were all targeted by Ong Wen's counsel. They all had telephone calls from Ong Wen in prison trying to persuade them not to testify. Various NGOs became very involved in trying to prevent them from testifying.
That's right.
It was a very fraught situation that they found themselves in.
Investigating and prosecuting war crimes, crimes against genocide, in and of itself, is difficult. It's not easy. You come against many challenges, but investigating sexual and gender-based crimes has even more you're really confronted with more challenges than other crimes. When it comes to the cultures, for instance, there are you'll discover early on that, for instance, in some places you cannot ask a male investigator to sit with a victim for the victim to be able to talk about what happened to them. just by the nature of the offense. And you also will find that for some of them, their cultures will not just allow them to even discuss this. So they will suffer in silence. So it's a lot of challenges, and one has to be innovative to be able to know, what do I do to get this evidence out without really making the person suffer again for what has happened. So you try and have the environment, you try and think out of the box on how do I talk to these witnesses, and how am I able to elicit this. Again, you also remember that we had victims and unit, a victims unit, not only within, not the GCU, the Gender and Children's Unit, but also the court has had the victims unit, in which they also, the registrar, will also organize victims protection unit, in ways in which the victims and the witnesses will be protected. So there are various ways. Of course, I'm not able to reveal all of that, because it's important that people don't know these things. But yeah, we also look for ways in which, and work very closely with the registrar to be able to have that protection that they need to be able to give the evidence.
Rita, can I bring you in here? I mean, you can say a bit about your work, and also maybe reflect on some of these issues in the area in which you've been doing your research.
Yeah, sure. It's like, I'll start by saying it's a real honor to be sat with both of you, Her Excellency Fatou Bensouda and Claire Wilmot. I'll start by generally what has happened in Tigray. In November 2020, the Ethiopian federal government and its allies waged a genocidal war on the people of Tigray. Around 600,000 people are said to have been murdered, and there was mass enforced displacements, destruction of infrastructure, obstruction of humanitarian aid. But one of the most highly used weapons was sexual violence. Women were raped, gang raped, enforcedly impregnated, enforcedly sterilized, and so on. This happened in front of their family members. It happened in front of their communities. It happened to the extent that some women have decided to end their lives as a result. Many of the women in Tigray are living with all of this and without any post-rape care or any justice. Currently, there is still ongoing conflict-related sexual violence. If I give you an example, if I was in Irob, the group that I represent, the minority that I represent, and I was raped, I was brave enough. Her Excellency mentioned culture. And in our culture, it's deeply, deeply stigmatized to come out and say, I have been raped. Your husband disowns you, the whole community disowns you. So if I was brave enough to come out and say I've been raped and walk to the nearest hospital, which is, if it's in Irob, 5 hours walk, imagine, after being raped, I would arrive at the hospital where it's completely destroyed, where I was there in January, and there was only antibiotics in this hospital. I would be told by a male nurse who has had no practice on conflict-related sexual violence that I should go to Adigrat, which is like a 5-hour, extremely dangerous bus journey, or I could walk for 12 hours. And then if I could get 350 birr to get to this place, and this walk or whatever did not prevent me, I would end up in Adigrat. If I got to Adigrat, I would have to find this one-stop center. In Adigrat, I cannot speak Tigrinya. If I'm from Irob, I'm from a tiny minority, and I only speak Saho, so I would only, at the maximum, be able to get, a HIV prophylaxis. I wouldn't be able to get any psychological support or any legal aid, which I'm supposed to get at a one-stop center traditionally. And this is what's happening. Like currently, almost like 15 to 20 women every day are going to this one-stop center in Adigrat now. 2 weeks ago, I was there. I was confronted by a 13-year-old girl who had aborted a 6-month pregnancy because she was held in sexual slavery by Eritrean troops. So this is the reality for women. If I wanted to seek justice, I could not. There's no existing mechanisms. With Ethiopia, what we tried to lobby for during the conflict was an independent investigation to the atrocities that took place. ICRI was set up, the Independent Commission of Human Rights Experts on Ethiopia. There was an international unwillingness for this to continue. The Ethiopian government used every weapon that it could to lobby Western governments to prevent this investigation from continuing. From the investigations that did take place, crimes against humanity, war crimes were found. But this is without the investigators actually going on the ground. They couldn't do that. They could only access refugees and people on the phone. So for this woman and so many women in Tigray, the law did not protect them. So I think, that's where we're at now. Go ahead.
And what does your NGO do? I mean, you work for an NGO, so your main aim is, if you like, bear witness to these appalling events, maybe in the expectation or hope that at some point it is taken up by an international tribunal or some kind of system to ensure a level of justice and accountability. Is that your aim?
Yeah. So I went to Sudan during the conflict, and I stayed there in the refugee camps because I could not access Tigray because it was blocked completely. And I stayed there for a year, going door to door, documenting crimes. Her Excellency was mentioning how to make justice more accessible for survivors. Right. One of the things that we do is we consult victims, direct victims of these atrocity crimes, and support them seek justice. We connect them with international human rights lawyers. We help them build cases and seek justice.
So let me ask you a sort of difficult question. You're working with these people who are going through in an appalling political situation, and they are facing atrocious social circumstances. Is a legal case against individuals going to make a difference in their life? Is international criminal justice going to be what brings them some improvement in their well-being, or does it just remind us why we have reason to hate people?
I think it's a good question, and I think every time that I confront a victim, I ask them, what does justice mean to you? And I get varied answers. But I think we have to understand that a lot of the victims that we confront are people who don't have food to eat or are displaced. So in this book, there's a group of survivors called, they've called themselves Mona Lisa, and they're justice-seeking survivors of sexual violence. They are currently, right now, in an IDP camp in Tigray. There they don't have adequate food, healthcare, or anything else. So their first objective, you'll read in the book, is to return home, to be returned to Western Tigray where they lived. And then they go on to accountability for the people that inflicted this upon them. And when they speak about accountability, they don't go for the low-level individual soldiers. They speak about the high-level, command-level perpetrators. Because they understand that the crime against them was systemic, and it was commanded. It was told to the soldiers to do to them. I think we also have to, if we see it from the survivor's point of view, it's that. But I also think we have to see it from an impunity point of view. Like, why should these people who are inflicting this pain on these populations get away with it?
But I suppose there are examples, including African examples, where that's precisely what's happened. I mean, you could say that the South African example was an example of that, that moving on, creating improvements in the well-being of people means a kind of setting aside of accountability. You're suggesting, I'm not quite sure, are you suggesting that that's not acceptable, that there has to be a holding of people to account, or do you feel that that other way, the kind of Truth Commission approach, the amnesty approach, is a viable possibility?
I think the Ethiopian government currently has a transitional justice policy that includes the kind of stuff that you're speaking about, amnesty and truth commissions and things like that. The example of the woman that I gave, the one woman who would have been raped in Iran, would have been raped by an Eritrean soldier, for example. And an Eritrean, in the transitional justice policy, Eritrean crimes are not covered at all. They're not mentioned at all in the whole policy. So victims of Eritrean crimes are completely neglected. And this is half of the population of Tigray. I think in an ideal sense, if truth is out, like if the government is able to admit what it did, if the people that were involved were able to truly admit and be sorry for what they did, I do believe some members of the population would accept that and move on. But I do think accountability is the most important here.
Claire, I'm sure you've got lots to say about all these things, and about this case, but also about how officials who are supposed to implement these new forms of legislation actually go about their work. I mean, it'd be really good to get your insights into that.
Sure, yeah, just to say I'm so honored to be here with Her Excellency Fatou Bensouda and Rita, who I've had the privilege of working with and learning from over the past couple of years on some work related to Tigray. But my work is not actually specifically focused on conflict-related sexual violence. So I think in my mind, our three roles can kind of be understood almost sequentially. So if the ICC is setting really important precedents, changing global cultural perceptions of what constitutes violence, sort of setting the agenda, if you will, for responses to conflict-related sexual violence and sexual violence more broadly. And Rita is doing a lot of the work on the ground of collecting testimonies, documenting, providing that link between people who've experienced these crimes, legal officials, helping people sort of see their options. So if Fatou Bensouda is sort of, expanding the realm of possibilities for survivors when it comes to seeking justice, Rita is helping them kind of actualize that and access those institutions that might support them. My work is a little bit different. So I study legal aftermath. So I'm interested in what happens after a law or a policy changes and how those new rules kind of filter down into practice in criminal legal institutions. So my work has taken place in both global South and post-conflict situations, but also global North contexts like Canada, where I'm from, the United States, and a bit in the UK as well. So I'm very interested in the way that law filters down into practice, how officials are using their discretionary power to assess which kind of victims do they want to devote their scarce time and resources to responding to. And I ask, what do those decisions tell us about how older forms of power like patriarchy or, national inequality, global inequality, race, etc., how are those forms of power persisting in spite of changes, these really important changes to legal frameworks that are happening at these higher levels. So just to say, that's kind of where my area of research lies. So I kind of see a bit of a sequence here, kind of the setting agenda, the establishing new avenues for justice, Rita sort of doing that groundwork, collecting testimonies, connecting people with legal institutions. And then I'm asking, how are officials responding to these requests from survivors? I'm very interested in how new laws and policies can raise expectations among survivors. So we saw after Me Too, for example, there was a significant uptick globally of sexual violence reporting. But at the same time, you see plummeting rates of prosecutions and convictions. And so the question in my mind then is, what's happening? What are people asking for when they're reporting sexual violence? And then what's happening later on down that process? So in terms of international law and conflict-related sexual violence, what I'm going to be paying attention to, particularly in the aftermath of the Tigray War, because as Rita said, a lot of this conflict-related sexual violence is ongoing, and particularly in occupied areas of Irob and elsewhere, is just, what do those everyday experiences of producing justice look like for survivors who are seeking something from these institutions? So that's kind of a bit about my research and how it fits in here.
Well, but we're talking mainly about African context here, so maybe just with a focus on that. What have you found out?
Well, I mean, Africa is a very big, diverse continent, and I don't claim to be an expert on the entire continent. My PhD research, a lot of it focused on Nigeria and the aftermath of the Violence Against Persons Prohibition Act, which was a sweeping set of legal changes to the Nigerian legal framework around responding to gender-based violence. But
do you find a kind of contradiction in your work? Maybe for both of you might want to answer this. Is there a contradiction at that level, the level you're talking about, between what people think is the right thing to do and what the law suggests they should be doing? Does that come up as an issue? Because the law is sort of externally generated, isn't it? And it, as Her Excellency was suggesting, people often have a very different view of it. Is that something that you've thought about?
I guess the victims and survivors that I work with tend to see law as kind of one form of power and one potential tool among many that shape and constrain their lives. So it's not necessarily that law sits on top of a neat hierarchy of rules that kind of, filter down, but it's one form of power. So a form of power can be oppressive, it can be emancipatory, and it depends on how you're able to use it. So in my own research in Nigeria, for example, a lot of these legal changes were fought for from the grassroots up. It was very much a locally driven agenda. These were Nigerian feminists who were fighting to overthrow colonial legal frameworks that had defined rape in very limited, narrow ways. And they wanted to create many more social protections for victims and survivors who came forward to report those crimes. Obviously, as is the case with so many legal reforms worldwide, a lot of these are not implemented, so we don't see people being able to access the kinds of protections that might have helped them access justice.
So one of the things that I've noticed, actually in many different parts of Africa, so it's almost like I haven't worked everywhere, but in most African countries in which I've worked, where an age of majority act has been introduced, that rape is very commonly the crime that is taken to a magistrate's court. But actually it's the father of the girl who is pregnant trying to extract money from the family of the boy and using the Age of Majority Act, and saying, well, she was under the age of 18, therefore the family has to pay money. And the magistrates' courts are full of that sort of debate and argument. But it's not kind of rape in the way that we've been talking about it. It's a kind of violation of property, isn't it?
Again, I think it's so important to be specific about context. And, the areas that I'm working on were urban. So, a lot of these cases did go to magistrates' court, but a lot of them were not. They were going to the high courts. And especially if they were reported to central police stations. It was sometimes the case that a case would be directed to a magistrate's court if there was kind of some corruption involved, or if the families were sort of trying to sway the case a particular way. But I would say those were, at least in my own experience in this specific context, were the minority of cases.
It's interesting,
Yeah.
because very often bribe price is so important to the families that it becomes the kind of focus for these discussions. But anyway, have you got any questions for the audience? I've got lots more questions. Yes, let me take one over there.
I just wanted to say something before we take the questions. I think the major problem that we're confronted with is the fact that in every conflict, almost every conflict, you find that there is sexual and gender-based crimes. You know, people are raped, people are gang raped. If you recall the Rwanda genocide, if you talk about Yugoslavia, if you talk about some of the cases that came before the ICC, some that are being investigated at the moment, and outside of Africa as well, not just in Africa, we see that the war, the battle, are fought on the bodies of women. This is what's happening. It's fought on the bodies of women. And an institution like the ICC is an international institution that is not dealing with, that is actually complementary to domestic jurisdiction. So ICC, as you know, will only step in as a last resort. So what I think needs to be thought about carefully is how do we have that filter down to the because it happens at the domestic level. We have these crimes, the sexual violence crimes, that I believe, you know, what is happening at that international higher level, we should have a way in which it will complement what is happening also at the domestic level. Because really, this is the problem. In all the situations of conflict, there is some level of sexual violence.
But I think you're also adding to that.
Yes.
You're also saying that, I think you explained very eloquently how in your role as a prosecutor, you've tried to kind of expand the way that gender-based crimes can occur.
Exactly.
And that complementarity works both ways, doesn't it?
Yeah.
The ICC has been crucial in driving an agenda in domestic perception in some places. I mean, and in some ways, that if there is space for hope in terms of national jurisdictions, I think that that role of the court is sometimes not perceived as much as it should be. I mean, certainly in areas of Uganda where I work, people are understanding that marriage by capture is not acceptable.
No.
And that makes a big difference for a lot of people.
Indeed.
Please, a question up there.
Yeah, thank you so much for a lovely talk. My name is Sakshi. I'm a master's student here at the LSE studying human rights and politics. I wanted to ask a question about the recent events at the ICC and ICJ. Has the lack of adequate response to the ICJ and ICC outcomes and statements with respect to the genocide in Palestine shown its lack of effectivity in actually protecting women and their needs and dignity in war-stricken zones? And how do international powers kind of navigate this almost power-based international order that seems to be straying away from a rules-based international order, where women from the global south especially tend to be the most serious victims from? Thank you.
Thanks. Yeah, let me take a few questions. So a very important question on Palestine. I suppose it almost could apply to Ukraine as well, I suppose, that question. Yeah.
Hello, so thank you very much for the very insightful talk and the sharing that you have just made. So I am Max and I'm a lawyer from Hong Kong, and really interesting to know about this topic. So there's a question that, or some insight that I would like to share. So recently I've just visited ICC actually. So I noticed that ICC actually in a level that it brings to the ICC level, there are certain type of elements or considerations that the court will consider first, and the prosecutor will decide whether to prosecute or not. So normally, it will like what the speaker had said, it normally being done like at a national level, or if the national level is simply out of control, or the state directly refer to the case to the ICC, then the prosecutor will look at several considerations and to determine whether to prosecute or not. And even though that there is a prosecution against someone who has conducted like severe gender-based violence or gender-based crime, sometimes it relies on the state parties to whether they will cooperate and to bring that specific person to justice, to the ICC court to be prosecuted. So this is the one observation that I've just made. So whether state parties, whether they will be cooperative to bring such criminal or such accused to the ICC to bring justice is one observation. And the second observation is that ICC has also its key priorities. So what I've observed from the ICC like recently, it's because they have organized like different, they might have ongoing investigations, or because of the limit of manpower and resources, they may only like target at specific times, like what happened in Israel and what happened in other places in the world, that really war crimes and other crimes against humanities are being happened. But for gender-specific crimes, it is normally being neglected. So I think for the future, I would like to ask the speaker, especially the prosecutor, the former prosecutor, that whether the ICC should bring more focus on gender-specific crimes, and even though that gender-specific crime will be focused, are there any difficulties apart from like gathering evidence or so? Thank you.
Okay, thank you. It's about the statute, I guess, and the referral mechanism. I mean, I remember when the Rome Statute was agreed, I think it was Geoffrey Robinson said that that states party referral is a problem because turkeys don't vote for Christmas, and generally governments are not going to refer themselves.
That's right. That's right.
Any other? Is there a third question? Yes, please.
Thank you so much. My name is Ramya Adiyar and I'm from King's College London. So this question is for Her Excellency. So you mentioned that ICC can only step in as a last resort. Then how can institutions like ICC better support national legal systems and prosecuting crimes of sexual violence against women in conflict?
Yeah.
Okay.
Thank you.
Yes, please, over there.
Yes, hello, Leon, Policy Officer with the LSE Department for Health Policy. It ties a bit to the first question, but we've talked a lot about advances in statutes, in legal requirements, but my question would be about the enforceability of it, and what can we do to improve how these things can be enforced when a fair share of countries are not even signatories to the Rome Statute, are not recognizing or supporting the ICC. What kind of leverage do we have that countries like Israel or Russia are not just ignoring these resolutions?
Thank you. Yeah. Can we take one more? Yeah.
Hi, I'm Isaac. I'm just a senior school student, and I have a question for Rita, and that is, in the conflict that you're aware of about the bus ride in the one-stop centre, how come in conflicts, specifically in the context, do sort of sexual violence and gender-based rape occur so often as a form of power? I'd just like to know that. Thank you.
Okay. Let's have responses to, I'm not trying to remember what they all are now, but we had two on sort of Palestine, sort of powerful states that are doing awful things. I mean, some of the answers to that is you've given in many of your recent statements about these things, isn't it? I mean, you came under such pressure when you were prosecutor. I remember your predecessor said to me at the Kampala review conference, he says, what could we do about the fact that we're prosecuting Africans all the time? It's because African states are referring cases to us, but I mean, that's not the case anymore, but the ICC doesn't have its own police force. So,
exactly.
You very courageously pushed forward the Palestine investigation, and you've been under a great deal of pressure over that. I mean, I don't know whether you have an answer to this question.
No, I think it's a very important question, the first question that you asked, regarding what is happening in ICJ and what is happening also at the ICC. I think first and foremost, we have to make clear that the jurisdiction of these two courts is different. ICJ, as you know, sits over governments and, and then they give legal opinions on certain things and also request governments to take certain steps. Like in the recent decision of the Palestinian case, they're asking that Israel take measures to ensure that genocidal acts are not committed. So it's really over states as such. But with the ICC, it's individual criminal responsibility. I think you know this already. I'm just speaking to those who know what I'm talking about. So, and it's a much more difficult thing for the prosecutor of the ICC to move. It's not as easy because, of course, first of all, we have to remember that ICC, I say it again, and I will respond to your question indirectly. ICC was established by states coming together. It is not a United Nations court. It is a court that was set up by treaty, in which in 1998 in Rome, that's why you have the Rome Statute, in 1998 in Rome, the UN community, or mainly international community, after several diplomatic conferences discussing the ICC and having the rules of procedure and having the statute, that they decided that this court will be established after 60 ratifications by states parties. So all those states who are with the ICC and our states parties have done so voluntarily. They ratified the Rome Statute. So if you look at what happened with that institution, you'll find that it is the fastest, amongst the fastest organizations that came to be established because of the way the world was. We want justice. We need justice. You had Yugoslavia. You had Rwanda. And then what we needed was a permanent international criminal court that will have individual criminal responsibility, not just states. So therefore, the processes that are, so in 1998, this ratification, this establishment happened. In 2002, ICC was established. So that's why I said it's fastest, because it's just 4 years. When you have treaties like the Children's Convention, which have, all of these other big human rights conventions have taken years before they came into existence. So I think it also demonstrates the thirst for justice, especially international justice that that people were feeling at the time. So coming to the ICJ, I mean, this was established a long time ago by the United Nations, I think in
League of Nations.
Yeah, League of Nations, actually, which became the United Nations. But so this is what they try to regulate, relationship between states. Now, the ICC, coming into existence, it was not just a court that was established, because many people felt that they were giving part of their sovereignty by just allowing the prosecutor of the ICC to just walk into any place and start investigating. So they said that the domestic jurisdictions will also be there, but they will only, the ICC will only act if there is failure at the domestic level to investigate and prosecute, whether it's by lack of political will or maybe inability to do so, but somehow those actions have not taken place and the prosecutor is given the power to step in. But also there is the provision that states themselves can refer, once they are a state party to the Rome Statute, they can refer the case to the ICC. And several states, in fact, starting with African states, several African states did that, and ICC started cases there. Now, the criticism against ICC was that ICC only had, at the time, African cases, is only going after Africa, when Africans were referring their cases to the ICC. So I'm glad that by the time I left, this criticism really is not valid anymore, because I had gone on to open the investigations in Afghanistan. I also, Colombia, there was Venezuela, there's Myanmar, Bangladesh. I mean, it's a long story and we don't have time. But just to say that this is how ICC works. ICC does not just go and take cases. It's complementary to domestic jurisdiction. It's when the domestic jurisdiction does not act that ICC steps in. And I think as a result of that, sometimes you see the prosecutor not acting, and many people think that, well, this is double standards, or, you know, but I know that sometimes there are limitations of jurisdiction in which the prosecutor cannot just go and act unless it can be shown that even where a state decides to say, I'm prosecuting, therefore ICC stay back, it has to be shown that they are genuine prosecution, and that it is not undertaken to shield somebody. Because all these tricks happen. All these tricks happen with governments. Nobody likes the scrutiny. Nobody likes the scrutiny. And as soon as you start, I have received a big pushback from Africa, my own continent, accusing ICC of prosecuting only Africa. You know, I mean, the last time I checked, I am African. But it was there, and all of that was propaganda that was made against the court. Also, a state can refer a situation to the ICC. And as I said, it's a long discussion, even with respect to the Palestine case, because Palestine initially was not a state party to the Rome Statute, but it became a state party under my tenure. And I opened investigations in that situation. Of course, after opening Afghanistan also, I was sanctioned by Donald Trump and also, but I wear that with like a badge of honor. But yes, it's, and I'm just trying to summarize. There are many questions, but I think it is important that we know how ICC works, the jurisdiction of the court. And also it is here to try and strengthen domestic jurisdictions, because if the domestic jurisdictions takes action and works, the ICC will not. Maybe at best the ICC will try to work with the domestic jurisdiction to be able to assist in them prosecuting for themselves those crimes. It happens in Guinea. Guinea, I remember I opened that investigations in Guinea. It was regarding the September events in which women were raped in broad daylight. So I took a long time in the spirit of cooperation and complementarity to talk with the Guinean authorities, because I was moving, I was going. And they had said that they are going to do it themselves. It took a long time because they did not have the means, the ability to be able to do that. But it took a long time, but finally a court was established, and last year I was so happy to see that trial started in Guinea. So this is how ICC has pushed the domestic jurisdiction under the principle of complementarity to do their own investigations.
I want to bring the other panelists in here.
Yes, please.
See, I mean, you got most of the questions actually, but there was one very important question which kind of went back over what we'd already kind of touched on. The point about, I mean, you said it yourself, when a war being fought on the bodies of women. I mean, could you say something about that? I'm thinking about the question here.
Isaac asked that question.
Yeah.
Yeah. Okay. Yeah. To answer, I think you said. Why is conflict, really sexual violence, why does it happen so often? I think it happens, at least in the context of Tigray, it happened to humiliate and to destroy these women and their ethnicity. So when these men would rape these women, they would tell them, we're here to cleanse your blood, we're here to make you infertile, to make sure that you don't continue to produce Tigrayan babies. So I think that's why it happens often. In the context of Tigray and the ICC, what you were saying, we have, like I said, like since 2020, when COVID, like not long ago, 600,000 people have been, civilians have been killed in Tigray. That's like the population of Manchester, gone completely. We have like 120,000 women, at least, that have been victims of conflict-related sexual violence. And the government was the reason that this happened, the federal government of Ethiopia. And because they have such, they're so popular, I guess, in the international community, and there's zero political will from any other country, no case has been brought to the ICC.
The commission was set up, commission of inquiry.
The
but the
commission
case
of
was,
inquiry
which I chaired a bit. But it's a commission of inquiry. And perhaps they would have been able to find evidence to ask for some form of action, legal action to be taken, accountability action. But the commission was set up by the Human Rights
the UN Human Rights Council.
Human Rights.
I mean, the Ethiopian government.
The Ethiopian government did not want to.
It's not going to refer itself. I mean, that's also. I mean, that's part of the problem, isn't it?
Human Rights Commission. Yes.
Yeah.
So that was set up, but a case was not brought to the ICC.
No.
Was what I meant.
Yeah.
It was the state's responsibility. I think often we think that it's. I don't know. I think there's a misconception that states are made to hold perpetrators accountable, but often we find that it's states that are perpetuating this violence. So I think I'll go back to after you a question maybe. So in the context of Tigray, the transitional justice policy that the Ethiopian government has created is essentially a fox guarding a hen house.
Yes.
It is the perpetrator telling the victims, "I'll give you justice." It doesn't have any international component, and it doesn't include anything in relation to Eritrea, which my family, like 10 members of my family are dead. There's no justice for them, opportunities for justice at least.
Sure.
What can we do, I guess, as a collective to try to hold the government of Ethiopia accountable for these crimes?
I'm going to just bring Claire in before. I'm going to give you the final word, but I'd like to get something from Claire before we end. I'm just looking at the time. So
I mean, I feel like all the...
Can you just summarize everything we've said so far?
I mean, maybe I'll just comment on what I'm most familiar with, which is the domestic justice systems. And, I'm always very interested in the conversations that are happening at the international level, conversations that are set, by a lot of the work that you were doing as prosecutor at the ICC, and the way that those filter down into domestic justice systems. And in my experience anyway, there is a form of complementarity happening in terms of conversations about cultural change. And by cultural change, I mean the culture of the institutions, the cultures of these legal systems that are saying, you know what, this is a conversation that's being had at the international level. So, I'm interested to see how some of these evolving situations in conflicts now will kind of filter down into domestic systems, but also it's, there's a lot of concerning things happening as well in terms of stonewalling, things not moving forward. And then my own work shows often that once a law does pass or a new precedent is set, there's still so much work that needs to be done kind of at the institutional level to make that happen. So that's...
I think it's... certainly one of the things that I have found most encouraging, I've already made this point, but I'll just make it again, about the International Criminal Court's involvement in parts of Africa in which I've worked, is that there is debate going on in villages, in local languages, which would not have occurred before. People are being introduced to concepts that they haven't thought about in that way before.
That's right.
And the International Criminal Court's involvement, even though it might be resisted by some and people complain about it, there is a discussion about these things.
Absolutely.
I mean, when I first started working in Africa, I worked in places where people were being killed and nobody cared. Maybe people still don't care very much, but people notice in a way. And the International Criminal Court has brought that scrutiny to parts of the world that haven't had it in the past, actually. And that's been hugely important. But there is this huge problem, I think, with the criminal court, in terms of the referral, which has come up in some of the questions.
Yes.
And you made the point very fairly that actually, those first cases of the International Criminal Court, of which there were many, were based upon referrals by African states. But African states that made those referrals were not referring themselves, actually. They were referring rebel groups that they wanted support in targeting. So you could argue, it's not an argument that I would make, but there is an argument out there that governments like the Ugandan government were drawn into a process, drew the International Criminal Court into a process of political expansion and control over territories of which they were unable to assert their power. I mean, that's probably a strong case to be made for Congo, a strong case for Uganda. This is going to come up in the Ethiopian case at some point too. So I just wonder what progress is there? I mean, is there a way in which we can move away from that limitation? It's a difficult question, actually. I don't know whether there's an answer to it.
But let me just come to the question that my co-panelist has asked, Rita. What is happening in Ethiopia, again, is horrible. In fact, I'm even beginning to feel that because of everything else that is happening, we are forgetting what is happening in Ethiopia, and it hasn't stopped, and the war is still on. So we need to refocus attention there. Ethiopia is not a party to the Rome Statute, which is rather unfortunate. And the only way that a non-state party, crimes that happen on the territory of a non-state party is able to come to the ICC is when the UN Security Council decides to refer the case to the ICC, like it was done in Libya and it was done in Sudan. It happened. Those were the only two referrals, but it hasn't happened again. In the case of Ethiopia, I don't know. I don't see it happening. The other way in which the case can also come to the ICC is if Ethiopia were to make a declaration accepting the jurisdiction of the ICC. This was also done. Ukraine did it, and I opened the case in Ukraine before I left, before even all of this is happening, because there was a referral over Crimea and all that happened. So Cote d'Ivoire also did it when they accepted ICC's jurisdiction without being a state party, and eventually they became a state party. So I don't see Ethiopia also making that declaration to accept the jurisdiction of the court. And this is why, again, this commission is crucially important. Because the commission, I think, will be able to collect evidence. In fact, that's how it started. As I said, I had the privilege to be appointed as the chairperson. But I resigned because I had other duties which I thought were going to conflict. And I did not want. I thought what was important was the commission, not me occupying that position. So if the commission makes these recommendations, I think there is a possibility, at least through there, of either the UN Security Council maybe rethinking this referral of Ethiopia, or at least setting up a tribunal that would maybe an internationalized tribunal, not just what is happening in Ethiopia. I mean, as you said, the fox is watching the chicken. So that is possible to happen. That an internationalized tribunal can be set up, and then they can look at these crimes, so that at least there will be some level of objectivity in the judges that are sitting if that tribunal is set up, not just.
And that would be a Security Council tribunal?
Yeah. No, it can also be a recommendation which is made to the UN by this Commission of Inquiry, because they were set up by the UN High Commission for Human Rights. So these are things that I believe can happen. But I agree with you. It's a very it's a very difficult situation.
I think you answered my question in answering that one, really.
Yes.
I think we have to end now, but I want to just end with one really important point, that the ICC is not going to go away.
No.
The ICC is a permanent court.
Yeah, yeah.
So people say, oh, the ICC can't do this, the ICC can't do that. Maybe that's the case, but it's not going away.
No.
So an ICC warrant is a bit like a papal excommunication, really. There's you take it to your death.
Yeah.
And that's really powerful.
And in fact, what someone commented that whether it helps in the domestic situation. I think it does. If a warrant of arrest is issued against someone, you know what happens.
Yeah.
The person cannot, unless arrested and brought before the ICC to be tried, you cannot travel. You are secluded to wherever you live, and a lot of consequences towards accountability can happen as a result. So I think the world with an ICC is better than one without.
Thank you.